Recording in progress.
Hello. Good morning, good evening. First of all, I would like to thank Professor Leonardo for the invitation and congratulate the organization committee who spared no effort in organizing this important academic meeting. I would also like to welcome all the people taking part in this meeting. It's an honor to share this discussion with Professor Laurence Boisson de Chazournes, who is an international reference for all researchers of international environmental law, like me. I would also like to thank Professor Rafael for his participation in this debate. Professor Laurence is a professor at the Faculty of Law of the University of Geneva. She is a member of the Institut de Droit International. She is the coordinator of the Master of Laws on Dispute Settlement at the Institut de Haute Étude Internationale. This is just a short summary of the professor's curriculum. The subject of her presentation is International Environment Law in light of the forthcoming 50th anniversary of the Stockholm Conference. Thank you very much for your participation, Professor. The floor is yours, please.
Thank you very much, dear colleague. It's a very kind invitation, and I'm really pleased to be with you. I must say that I'm a great supporter of the CEDIN in Brazil. Professor Leonardo is a friend of a long time, and I'd like also to thank Fernanda Lada for organizing everything. And I must say that it's a pleasure to be virtually with all of you. So, as you may know, we're going to have a course for 1 hour, and then we will have a discussion. And I'd like also to mention that I'm especially pleased to have this discussion with a very nice colleague who has introduced me, but also with Dr. Prado, who was a researcher at the University of Geneva. So I'm going to be discussing and we will try to put the diaporama, and you can have access to it afterwards if you would like to have it. As was said, I'm going to be speaking about international environmental law, and we will be celebrating a sort of anniversary, which is the 50th anniversary of the Stockholm Conference, which took place in 1972. And so I thought that it would be, and we will celebrate it next year. And I thought it would be important to take stock of what has happened since that time. But for understanding what has happened since that time, we have to put international environmental law in context. So for doing this, we will be, what I'm going to do first is to sort of locate the international environmental law. And we're going to be realizing, and I will stress that later on, that in fact, we've been speaking of international environmental law only quite recently. And recently for me, it's a perspective. Of course, you're all very young, I'm a bit older, but it's only in the early 70s that we started to speak about international environmental law. Okay, so what I want to say with that is that there was you can't find a corpus of norms and principles before the early 70s, which was dedicated to international environmental law. What we had, and I'm going to stress that just for you to locate it in the field of international law, is that since the end of the 19th century, the early part of the 20th century, we had a few treaties, we had a few cases, judicial cases, which were dealing with issues related to environment. And for that, I'm going to give the example at the beginning of the 20th century of the law related to the exploitation of resources, the catching of whales. At the end of the 19th century, early 20th century, this was a very important economic activity. And states felt that it was important to regulate the catching of whales, not because they wanted to protect the whales because they were constitutive parts, components of the environment, but because they were natural resources which were producing economic gains because of the oil, because of different issues. And so I don't think that when we speak of the old conventions in relation to the whales, to the catching of the silphurs or so on, we are speaking of environment. We are more speaking of how to manage an optimal exploitation of these resources. Okay, it's really in the 70s, 80s that states are going to be linking hunting, fisheries to the protection of the environment. Okay. Now, in the 20th century, because of the industrial activities which were conducted, states started to realize that we could not isolate. They could not isolate each other from the impacts coming from the territories of other states. And so they started to realize that a pollution which was produced on the territory of one state could have consequences on the territory of another state. And for the international lawyers, you might know in the books, you might have read about the Transmelcher Arbitration. This was a case which opposed the US to Canada. And this was because of pollution in the western part of Canada, which had consequences on agricultural products in the United States. And there was a tribunal which was put in place, and there was compensation which was ordered, and so on. But what I think is interesting is that if you read carefully the award of 1941, you will see that the tribunal was not really speaking about the protection of the environment per se. They were speaking about the effects of certain emanation of dioxin. It was the dioxin of sulfur that could SO2 that caused problems in the United States. But they were not yet looking at the environment from a holistic perspective and thinking that all emissions of SO2 can have an impact on the air, on the health, on the environment, and so on. So, all what I want to say is that those cases were sort of ad hoc cases and limited cases in their ambit, and they didn't really speak about the environment per se. So, with that, I just want to set the stage to show you that, in fact, we started to speak about the environment, the protection of the environment, only as from the 60s, okay, as from the 60s, and much more as from the 70s. So now what happened in the 60s, which brought us, when I say us, it's our parents, our grandparents, it's us, and it's all the people who are going to come after us, okay? So it's a perspective of the human population, okay? Why did we consider that there was something to be done about the environment? Because there were some voices which started to speak in the 60s. And for example, Rachel Carson's book, Silent Spring, is a good example. She is an American, she's an American author, and she started to realize that she would no more hear the songs of the birds. She would not hear them. And she wondered why. And this was due to the use of pesticides, okay, which was destroying the habitats of some species and so on. She wrote a book, Silent Spring, which had some impact on people, not everybody, but on people, realizing that there was something that we were doing, we human beings, on the environment, which was destroying elements of the environment. In the 60s, 70s, we also had economists who started to say, look, what is this story about economic growth? At a point, if we continue with this, we're going to be consuming all our natural resources. They are non-renewable. And what are we going to do if we don't anymore have what we call the environmental capital? Okay, so voices, economic voices. Then we had some maritime catastrophes. And in Europe, in the United States, but also in Brazil, but people would not speak a lot about them, where people realized that if we were not protecting the shores, the coast of a state, there would be severe impact to the countries, but also to the sea with these maritime catastrophes. And lastly, another element, which I think had also a very important impact, it's the fact that in Europe, in the United States, in Japan, people realized, we're starting to think that there was a need for a change of the political governance system. And that's what we call in Europe, in France, the May 68 movement. It's a movement of ideas, okay? And among that, there was this idea that we should change our way of looking at how we're related to the environment. And it's really at the end of the 60s, early 70s, that what we call now the Green parties, and you have a very important Green party in Brazil, was constituted. It was really at the end of the 60s, 70s that people realized that the environment was also part of the daily life of people, that it was an element of the political system, and that it should be looked at from this perspective. So those are some elements just to show you that there was a burgeoning of ideas, a conjunction of ideas, which brought people, our leaders, to think that something had to be done. And what happened was the convening by the General Assembly of the Stockholm Conference on Human Environment in 1972. Okay, so this is a very important time for those studying international environmental law, because it's at this time that we had the first UN convention, the first UN conference dedicated to the environment. And what is interesting, and it will always be the case with conferences of the United Nations dedicated to environment, is that those who were invited were states, international organizations, NGOs, associations, and the private sector. And that, I think this is something that you have to remember, that the private sector has always been looked at as a very important actor for transforming our way of dealing with the environment. So you see, 1972, it's an important time for the environment. And next year, we will be celebrating the 50th anniversary of the Stockholm Conference, and it's going to take part in Brazil, in Rio de Janeiro. Okay. Now we move. What happened after 1972? So what happened is that 20 years after the Stockholm Conference, there was a need to take stock of what had been done. There were also movements saying we protect the environment, but in fact, there are major challenges which are global. In the 80s, we started to speak of climate change, of biodiversity loss, of the ozone layer hole. We started to speak about desertification and so on. And so the United Nations General Assembly decided to convene another conference 20 years after the Stockholm Conference, which took place in Rio de Janeiro, which is the Rio Conference on Environment and Development in 1992. And on this PowerPoint, I speak of universalization. Why do I say so? Because I think that in the 70s, it was mostly an issue in the Western countries. Okay, the Western countries realizing that they had destroyed their environment, the environment, and that something had to be done. In the 90s, what is interesting is that all components of the international community agreed that we had a common stake, we had a common challenge, which was the protection of the environment. But because there were countries from the south, countries from the north. Well, I speak in those terms because I'm located in Geneva, but would I be on another place in this planet? I would use other words, but it's the words of the United Nations. But the compromise for the southern countries was to say, yes, the environment is very important, but we also need to speak in terms of development, because we also have to feed our population. We have to give work to our population. So we'll come back to that, but a compromise was forged, and the conference is named Rio Conference on Environment and Development. Very important instruments were adopted, such as the Rio Declaration on Environment and Development, and I'll come back to that, and the Plan of Action, Agenda 21, which is a plan of action which is still producing effects in our countries and at the international level. So you see that conferences, and each time we're taking stock of what has happened, and we try to sort of think about what should be the priorities. So there is another one in 2012, which takes place in Rio de Janeiro, and there, I think it's not really, the concerns are no more really normative, what are the rules, but more institutional. Why is it that at the international level, we can't sort of have an effective governance system so that the environment has a voice? Okay, so they will try to change the bodies, the international organs, which are going to be in charge of the environment within the United Nations. And then comes 2022. That's going to be next year. And it's the 50th anniversary of the Stockholm Conference. So as I've said, 50, for most of you, it's old. For me, regrettably, it's young. But it's a long time, and it's not a long time. And I think that what I want to do with you this afternoon is to think about what has happened for international environmental law. So far, what I've done is to show you that since the early 70s, there's been a growing awareness that something has to be done with the environment. At the international level, the way to think about the environment has been through organizing conferences, to take stock of what has happened, and then to try to think about the future. Now, Stockholm, I think, is going to play a very important role, because I think that today, and your generation is going to be very important, environment is no more a marginal issue. In the north, in the south, in the east, in the west, it's no more a marginal issue. It has become, I think, the issue for the survival of humankind on this planet. I don't want to be dramatic, but I really think that it's a question that we all have to be in charge of, because without a sound protection of the environment, it's not possible that we're going to remain 10 billions on this planet and that we're going to be living peacefully. Now, the environment, we know that, has a relationship to economic relationships, it has a relation to human rights, and it has a relation to peace. Without a sound protection of the environment, we're not going to guarantee peace and sustainable peace. And think about the origin of a lot of conflicts today in Africa, in other parts of the world, and you will see that access to natural resources is one of the important drivers of conflicts. So let's look at what has happened, how we've developed international environmental law. So that's going to be I can't move this. I don't know why I can't move it. Just wait a minute. It's frozen. What should I do? It's okay. So what has happened? In fact, a lot. And this is what I'd like to also stress, is that and the people who know me and who are listening to me know that I'm not a pessimistic person. I'm an optimistic person. But what I think is that we can always improve and we can always do better. Okay, and we learn from our mistakes. We learn from our errors. So let's see what happened. So we start in the early 70s, and there everything has to be built because we don't have any instruments dealing with the protection of the environment. So states are going to have a lot of appetite for developing instruments, negotiating treaties, adopting soft law instruments, dealing with the protection of the environment. So we have examples. For example, you might have heard of the Ramsar Convention, which is dealing with the protection of wetlands of international importance. So that is going to be an important phase where states are going to be adopting convention, the CITES Convention, the one dealing with the species in danger. Okay, so they adopt conventions. Then within UNEP, they discover that there are problems with the seas, and they need to protect seas. And so they're going to develop a series of conventions and so on. And what we notice, and that's why I've used this notion of sectoral approach, is that they're going to be looking at an issue, a problem, and they're going to try to fix it with certain techniques. Okay, so that's what I name sectoral. So protection of wetlands. There are wetlands in danger. We're going to do a list, and we're going to look at the human activities in relation to the wetlands. Species in danger. We are going to be limiting, restraining, prohibiting the hunting or the fishing of this species. Seas, we're going to prohibit the dumping of certain substances so that to protect these seas and so on. But as you see, there is a problem, and we identify one or two or three techniques. Okay, it's sectoral. Those conventions are very important. They are still producing a lot of effects. Their mandate has been enlarged, but there are important instruments. But what is interesting is that in the 80s, states are going to realize they're going to start to listen to scientists. We're going to tell them, look, human activity has developed in such a way that it has an impact on the climate. Okay? And that is the issue of climate change, the greenhouse effect. It's the issue that because of the emissions of certain greenhouse gases, there is an increase of the temperature on Earth. And because there is an increase of the temperature on Earth, there are impacts, okay? And the raising of the sea level is something which is a great concern for a lot of countries. But it's also desertification in a lot of regions of the world and so on. So awareness that there is an issue like climate change. Scientists are telling you can protect certain species, but if you don't protect the biodiversity as such, it's going to disappear. And they say there is a loss of the biodiversity. Okay? So awareness, what to do, and so on. Then the ozone layer, the hole above the Antarctica, and the realization that the emissions of CFCs is important. It's contributing to the destruction of the ozone layer and so on. Desertification, the pollution of the seas and so on. What I want to stress with that is that in the 80s and early 90s, states are realizing that there are issues of environment which are global by nature. It's not just an issue that you can identify, because in fact it's an issue which has impacts on different regions of the world, and it can't be fixed by one or two techniques. When we speak of the global environment, it means that you have to transform the economy, you have to transform the agriculture, you have to transform the tax system, you have to think in terms of health, which have not been thought about before, and so on. So it's a new approach. It's a revolution, because that means that we all linked one to each other, and we're all dependent of one to each other for making sure that there can be human survival on the planet. So the second generation of convention is going to be adopted in the 90s. And at Rio in 92, the states are going to adopt and open to signature the Convention on Climate Change and the Convention on the Protection of the Biodiversity. And later on, it will be the Convention to fight desertification. Now, and you know that maybe if you've read about the environment, the scientists are telling us, yes, it's good. There's different conventions and they can produce certain impacts. But in fact, everything should be looked at from an holistic approach, an holistic perspective. And they say, you can't fix the biodiversity if you don't link the biodiversity to climate change. You can't fix the issue of climate change if you don't link it with the ozone layer. You can't fix the issue of biodiversity if you don't look at the wetlands, and the wetlands, we've destroyed them in the 20th century and so on. So the scientists are telling us, in fact, everything is related. And in fact, we should have a super global approach to everything. It's what I call the holistic approach. The question for us, and it's going to be for your generation, is it feasible today to discuss or to negotiate a treaty which is going to cover all the issues altogether? There I'm a bit pessimistic, and I don't think that time is ripe for that. But what we see, and it's interesting, and for those interested in political sciences, there are some insights which are interesting, is that we see more and more links between the regimes, okay? So there are memorandum of understanding which are negotiated by the secretariats of the different conventions, and they're trying to have a common language for dealing with these different issues. But I think that today it's really the holistic approach which is at stake. And I think that there are different legal ways of dealing with this holistic approach. Then there is also something which is very important, which is that what I call often is that we've developed a language. I think we have developed a language in international environmental law. We have now a common language for all of us. The problem is that, does this language have any impact on the ground? Is there effectiveness? Okay, and that's the key word today. Can all these conventions, do they really produce effects that we can see on the grounds? Okay, and there we have a new movement which has arose in 2015, which is carried by the 2030 Agenda for the Sustainable Development. That's an agenda adopted by the General Assembly of the United Nations, which has identified 17 Sustainable Development Goals, and which has said by 2030, all human beings should have access to water. All human beings should be able to benefit from a climate which is not going to be, where the temperature is not going to increase, and so on and so on. All human beings are going to be able to benefit from a biodiversity system which is effectively protecting the biodiversity, and so on. And so what I want to say is that what we see in international law is that more and more, aside from the normative discourse, which is very important, we have a new trend which is emerging, which is the testing of the ground, which is what I call the effectiveness. Okay, and you can look at the website of the United Nations on the 17 Sustainable Development Goals. We still have a lot to do. We've not done much, okay? But I think it's an interesting perspective because now we have set ourselves goals, objectives that we have to achieve. We can come back in the discussions on the notion of effectiveness. Now, one thing I wanted, before I move to other issues, is that I've been speaking about the environment now for 30 minutes, but you've realized that I've not defined the environment. And usually people don't define the environment. It's as if we all know what is the environment, okay? But in legal terms, you know that we lawyers, we like definitions, okay? So what is interesting is that if you look at the conventions, you will see that there are very few instruments which are defining what is the environment. Maybe certain conventions on the liability, because they need to assess what is an environmental damage. But otherwise, we don't have a definition. We take for granted that we know what is the environment. So I put on the PowerPoint this definition because I think it's an interesting one. It's a definition which was given by a tribunal which rendered a decision, an award, in 2005. Alverne, which it's a dispute which opposed the Netherlands to Belgium. And there you see the tribunal says environment is broadly referred to as including air, water, land, flora and fauna, natural ecosystems and sites, human health, safety and climate. I just want you to keep this definition in mind because we don't have time to discuss it, but just realize that it's very broad. It's natural resources component, okay? It's also ecosystems. You know that ecosystems, those are phenomena, natural phenomena, it's a system of interactions among different natural components. They speak of sites. That means that the aestheticism has also a role to play, or culture has a role to play. You know that a lot of sites are important for indigenous populations, for example. Human health. So we human beings, we're part of the environment, okay? And our health is dependent on the protection of the environment and so on. Safety and climate. Okay, so that is one definition. But I think it's an interesting definition because it shows that the international environmental law is not a marginal field, and environmental law has a broad scope in terms of protection. Now, which are the instruments which are used to protect the environment? And then we come back to the legal instruments which can help us protect the environment. So first, I'd like to start with saying that international treaties play an important role. Okay? International treaties play an important role, and it's through these treaties that a lot has happened, because these treaties dealing with the environment, the Ramsar Convention, CITES, the Biodiversity Convention, the Convention on all the pollutants, the chemical pollutants, and so on. What they bring their norms with us, but they also bring their institutional apparatus, because the secretariat is going to be put in place, a conference of the parties is going to be organized, and so on. And so what is interesting for us is that once you adopt a treaty or a convention, then the institutions which are put in place are going to develop the language of the treaty to further the objective of the treaty. Among the treaties, there is a special category of treaties that have to be noted. It's what I call the framework conventions. The framework conventions, and they are specially adopted for the global environmental issue. The framework conventions are used for having all the states of the international community to agree to deal with a specific issue. In Rio in 92, the UN Convention against climate change was adopted as a framework convention. We developed a frame of action. Biodiversity, the states in 1992 adopted a framework convention. And the idea of the framework convention is that subsequently, states are going to refine the content through protocols. Protocols are treaties, but they are treaties which are going to complement the framework convention. So we had the Kyoto Protocol for dealing with climate change. And today we have a strange additional instrument, which is very important, which is the Paris Agreement, okay? Which is a sort of protocol because it's linked to the UN Convention of 1992. So we have treaties, we have special categories of treaties, so to develop further the regime. And for us, what is interesting is that the institutions, like the Conference of the Parties, the committees which are going to be put in place, they're going to adopt decisions. It's what we call secondary law, secondary legislation. If you look at the architecture of the climate change regime, you will see that a lot rests on decisions of the conferences of the parties. Well, that is to attract your attention to something which is very important, is that there are different normative tools, normative treaty tools, which are used for developing the regimes dealing with the environment. So that's for treaties, and they play a key role. Now, we have another source of international law, which is customary international law. And there, among the norms of customary international law, we have principles, the principles dealing with the environment. And we know that these principles are very important because they're going to be, in my words, they're going to be the Trojan horses. They're going to enter into the different regimes of regulation. And they're going to say, we are the environment and we want you regime of trade, you regime of human rights, you regime of tax. We want you to take us into consideration because the environment, we're carrying environmental protection with us. So those principles are the principle of prevention, the principle of environment impact assessment, the principle of cooperation, the principle of sustainable development. And I've just listed some examples, but you also have the principle of public participation, which is important. Now, and Dr. Prado can come back to that later on, is that the big question is that what is the status of these principles? Are they all principles of customary international law? And some courts and tribunals have considered that they are part of customary international law. Others have looked at them and they said, no, it's an emerging principle. It's not yet a lex lata principle and so on. For me, this discussion, I think, is now behind us because there are a lot of principles which have, in fact, been admitted as principles of customary international law. And that's why I want to say when I say that there's been a phenomenon of incremental legal maturity of these principles. So that is the role played by customary international law. Then, the positivist, if there is no treaty, if there is no custom, is there another source? What I think is that, the division between hard law and soft law is not tenable. And I don't think it's an interesting one. Because I think that instruments of non-binding instruments play also a very important role. And with that, I want to say that the Rio Declaration, which was adopted in 1992, the Rio Declaration on Environment and Development, which enunciates 26 principles, is a key instrument. Because if you look at the different regimes of international law, at the case law, you will see that it's an instrument that has been referred to for saying, yes, we need to take into account the protection of the environment. So just to highlight, okay, and you will have other courses dealing with the sources of international law, that soft law plays an important role because it shapes the way we think. The soft law shapes our way of behaving and so on. So beside treaties, customary international law, soft law instruments, we have a fourth category of instruments which are playing an increasing role in international law. When we speak of treaties, when we speak of customary international law, when we speak of soft law instruments such as the Rio Declaration on Environment and Development, we are speaking of instruments which have been forged, which have been developed, elaborated by states, which are the key players in the international system. But what is interesting is that more and more other actors are going to play a role for shaping our way of protecting the environment. Among them, there is the private sector. The private sector, for exchanges, for international trade, they need predictability. They need security. And so they're going to participate to the definition of technical regulations, which are going to be adopted by others, so that to be sure that the exploitations are not going to be stopped and so on. And you might have heard already of the International Standardization Organization, ISO, International Standardization Organization, which has its headquarters in Geneva. It's quite interesting because it's an organization where you have representative of the private sector, of the public sector, and so on. And they are elaborating standards, key standards for the protection of the environment. So those standards play an important role for those who have studied international trade. If you look at the TBT treaty, the Technical Virus Treaty, you will see that, in fact, there are references to these technical standards. And then among these standards and technical regulations, we have the self-regulatory instruments that the private sector is adopting. Because the private sector knows that the society now wants them to be accountable, to be sure that what they're producing is not produced with material which is destroying the environment. So a lot of groups of societies, of companies are elaborating, adopting codes of conduct, codes of conduct, or they are adopting technical regulations that they commit to respect, and so on. So it's just a few minutes on this source of international law, but I think it's important to realize that maybe it's a bit too much, but I think that the states in the field of environmental protection, the states don't have anymore the monopoly of lawmaking. They still play an important role, but I have realized that if the private sector, the NGOs or the technical associations are not involved in the lawmaking of international environmental law, there will be weaknesses and it would not be sufficiently effective. So we have now this plurality of sources which is appearing on the international stage. So there we have spoken about the tools that we have, how we make international environmental law, which are the legal tools. Now, what I'd like to do before we conclude and we exchange is also to speak about a few challenges that are with us when we speak about international environmental law. And first, we have temporal challenges. What do I mean by this? I mean that in the field of international environmental law, we have a paradox. Because we are reacting to events, we are reacting to an increase of knowledge about the destruction of the environment. So we are adopting new instruments and so on. But at the same time, we are asked, we international environmental law, to anticipate, to prevent. And so you need, when you are dealing with the protection of the environment, you need to take into account what has happened, what are the reasons, which are the reasons for the destruction of the environment. But at the same time, you need to think about how to anticipate any degradation to come, and so on. And we all know that states are important actors, but states in their great majority are conservative. Okay? So they're reluctant to project themselves in the future. And we see that with climate change. It's very difficult to have states to commit to decrease of emissions, which are going to be drastic, and they should be drastic if we want to limit the raising of the temperature on our planet. So it's a first element, reaction and anticipation, and the need to react, but also to protect ourselves in the future. In this context, I think what is important is that we need to think in terms of processes. It can't happen all of a sudden. So, and that's what we've seen with the sources of international law. We realize that there is something which has happened. So we adopt a treaty, we adopt a standard, but we know that we don't know everything. So what we have to come back to the issue. And that's a process that you put in place with the help of scientists, with the help of technical experts and so on. So to think about how to improve what we've done. So the adoption of protocols, through the adoption of decisions of the contracting parties and so on. So processes for us, it's very important is that when you look at a regime, you can't just look at a treaty. You have to look at the set of the gathering of all the instruments which are interpreting and developing the treaty at stake. And then we have a very special concern and principle in international environmental law. That is what is called the intragenerational and intergenerational equity. Intragenerational equity, that means that this is something that we've been speaking a lot about in development terms, is that there should be intragenerational equity among us. We in the north, you in the south, in the west, in the east, there should be equity. We should be able to have access, to all have access to water, to all have access to vaccines, to all have access to health, and so on. That's what we call the intragenerational equity. But besides intragenerational equity, there is the notion of intergenerational equity. Intergenerational equity, that means that we, currently on this planet, we owe something to the generations to come. And we should make sure that the environment that we're going to live for the future generation is going to be as good, and maybe better, not really good, than the one that we have. That means that we are custodians of the environment, and we have committed to protect the environment so that the future generations are not going to inherit from an environment which is going to be severely degraded or destroyed. And this is interesting because in climate change terms, we have now decisions of courts and tribunals who are telling the states, and that has happened very recently with the Constitutional Court in Germany. Your climate change plan is not good because in fact you're not doing sufficiently between 20 and 30. And that means that because you're not doing sufficiently, the generations which are going to come afterwards will have to do much more. And this is not equitable because you also have to take into account the future of the generations to come. So I think that's a key principle, and we still have to define it and refine it as much as we can. So that's the first feature, temporal challenges. Second feature, it's sovereignty and its imprint. And that, what I want to say is that there we have a political structuration of the international community which is done in accordance to states and states' sovereignty on territories, specific territories. But now we've learned with the environment that borders don't protect. Borders are there for political reasons, to know how far a state can exercise its sovereign prerogatives. But borders are not going to stop the emissions of greenhouse gases. Borders are not going to stop the loss of biodiversity and so on. Borders are not going to help us with maritime pollution and so on. And what we've realized with international environmental law is that if states want to do something about the environment, they need to cooperate. And they need to accept that they have a common interest at stake. And I just want to highlight this because, and you know that, because you are living in a country, the majority of you, Brazil, where the principle of sovereignty of the natural resources is an important principle. And it's an important principle everywhere. And I think it has been very important also in Africa at the time of the decolonization, because the states have said, we want to manage our natural resources as we want, okay, and to the benefit of our population. But at the same time, and I just want to stress that at the same time, we have this principle, but we also have the challenge of the protection of the environment. And when we put together sovereignty and the protection of the environment, at first glance, the protection of the environment is going to restrict the exercise of sovereignty, because we're going to tell a state, you can't anymore have these nuclear plants in regions which are very dangerous for the population. You can't anymore give forestry concessions as you want, because there is a need to protect the biodiversity and certain and the forests and so on and so on. So what I just want to say is that yes, we accept that cooperation is great, but then you have to see how cooperation is going to work. And sovereignty and the protection of the environment, what we've tried since 1992 is to say it's going to be the links between sovereignty and the protection of the environment are going to be encapsulated in the notion of sustainable development. What does it mean, sustainable development? And I challenge you, because I don't think that we know yet what is an effective protection of the environment in accordance with sustainable development. For the time being, what we've done compromises. You can do this, but you should take into account this, and so on and so on. We have not yet fully thought about how to exercise sovereignty in a sustainable manner. And that, I speak about climate change. Okay? Fossil fuel should no more be used. Okay? They will continue to be used for a certain time because we don't have other sources of energy. But a lot of countries know that in 30 years from now, it will no more be possible, really, to use fossil fuel if we take seriously into account the protection of our climate. Okay? So what I just want to say is that for the time being, we are still learning, but we don't know yet in a clear manner how to reconcile sovereignty and the protection of the environment, especially through the concept of sustainable development. Another feature, which I think is important, and I'm just going to mention it, it's that the norm, the principle is important, but we need institutions. We need institutions to help protect the environment. So what is interesting, and that is something maybe that will be discussed next year, is that when we had the Stockholm conference in 1972, if you looked at the constitutive agreements of international organizations that were present in Stockholm, none had the concept of environment in their charters. But through the implied powers theory doctrine, they decided that the environment should be an important concern. Nowadays, all institutions are dealing with the environment. Okay, WHO, FAO, ILO, UN, Security Council even, and so on and so on. In 1972, we didn't have an institution dedicated to the protection of the environment, and it's in Stockholm that the states decided to create UNEP, the United Nations Environmental Program, okay, which is located in Nairobi. So institutions are important. I think a question for us, a fair question, is that do the institutions, are they doing sufficiently? Okay? And should they develop other tools and so on? When we speak of institutions, and that's something that's for these two other points I would like to stress also with the environment, is that the environment is never have we said that it's only the states which should be acting or intergovernmental organizations. Because right from the beginning, it has been admitted that if the global and the local are not working together, nothing is going to really happen. So NGOs are crucial actors, but also the private sector. And we have more and more what we call public-private partnerships. Public-private partnerships, which are, they are gatherings of public and private actors with objectives, so to protect the environment or the health. Now, among the institutions for us lawyers who play an important role are the dispute settlement mechanisms or the compliance mechanisms. I think that one of the big challenges for these mechanisms that we have is that they need to make the states understand that there is a common interest. There is a common interest for protecting the environment. So this is why we've seen compliance procedures which have been developed, which are interesting because they are trying to sort of identify what is the common interest of the states in the field of the protection of ozone layer, in the field of public participation, and so on. And then to mention them, because I think it's quite interesting, the courts and the courts and tribunals are playing an increasingly important role. And it's quite interesting that courts and tribunals, international courts and tribunals, but also domestic courts and tribunals, are more and more aware that they need to tell the private sector, they need to tell the states, public sector, that what they do is not sufficient, that they should do more. And in that respect, I think that there is a sort of legislative approach by the courts and tribunals for educating the states, educating the various actors of the international community. And I must say that I'm more and more interested in the decisions given by the domestic courts, because I think that they more and more have a vision that is very creative. And I really think that the judges have to be congratulated, and they should find the ways to be trained so that they could help improve and make more effective the protection of the environment. So to conclude, where do we stand after this tour de horizon, after this sort of gathering of what has happened in the last 50 years? I think that what we can say is that there is a growing understanding among states and other components of the international society of the importance of international environmental law. And I think I can say that from a marginal issue for a lot of countries and people, international environmental law has become a mainstream issue, okay? A crucial issue. Something also that is noticeable, and especially through the resort to principles, is that other areas of international law more and more are making space for the protection of the environment. And I mentioned, for example, the field of human rights, but it's quite interesting to see that human rights, now the environment is taken into account in various contexts. And I must say that the Inter-American Court of Human Rights is an important institution, jurisdiction, which has shown us that the links that we have between the protection of human rights and the protection of the environment. Okay? But if you look at the trade regime, be it the World Trade Organization or the free trade agreements that are concluded by all the countries, you will see that now they have a chapter, they all have chapters dedicated to environment. This was not the case 20 years ago. Okay, so as I said, greater convergences. Now, what does it mean? And how to fix it? So, last week I was at a meeting where we had to think about how to integrate better the environment within the World Trade Organization. And you know that there is a committee dealing with trade and the environment. So they asked me, what a seed for thought, what do you think? And I said, we should find a new language. Why speaking of trade and the environment? They should go together. The and should be deleted. But it's for you, your generation, to be building these instruments of integration. So to end, quite a lot has been done. Quite a lot has been achieved. But in terms of effectiveness, it might be too little. So the effectiveness, I think, has become the big challenge. We have, as I've said, we have the language. We have the common language for all of us. But we need now to make this body of law effective. And that we need to ensure that everybody is going to benefit from the protection of the environment, and this is not yet the case. And it's not yet the case everywhere in the world. In Switzerland, in France, in the United States, in Russia, in China, in Brazil, everywhere, we still have to work a lot for ensuring a sound protection of the environment. So with that, I will thank you, and we hopefully will have a discussion. Thank you.
Thank you, Professor Boisson Chazournes. I get the floor after your brilliant speech. It's always a pleasure to listen to your lessons. So please, I would ask the attendance students or other colleagues, if you have any questions, please write for me or Fernanda or Professor Tarin that we are going to pass to Professor Boisson Chazournes, or you can do by yourself as well. So I have one first question from Murilo Fagundes. He's one student here. Hello, Murilo. Thank you for a question. Murilo is asking Professor Boisson Chazournes, in your opinion, what is the biggest difficulty in the international system to create a global, holistic international treaty for the protection of the environment today, and that this treaty created binding force?
Do I see the author of this question? Mariana, is that you have your hand?
Murilo is here.
Okay. It's it's nice. Yeah, I see Mariana. It's very important to see the people because it's difficult to have it. I think that it's a generational issue. For the time being, we have been educated with a fragmented way of thinking, especially we, us lawyers, civil law, criminal law, commercial law, the law of the sea, and I think that we need to have a common sort of language, or a common set of words which are going to help us to link all these issues all together. But I think that it's going to be step by step, and I don't think that we should insist on having a holistic treaty, because it seems to me that already if we can forge links, create bridges between the different regimes, we will already have done a lot. And it would be wonderful is in conferences dealing with climate change that people speak about biodiversity. Already, this would be a first. And we should maybe, if we are interested in those issues, we should find a way to always spread the word of the linkages between the different elements of the environment.
Thank you, Professor. We have another question for Mariana. Mariana, please, you have the floor.
Good morning to my colleagues in Brazil. Good afternoon to those in Europe. Professor Laurence, we're talking about sovereignty, and my question is a bit specific. So I'm thinking about this topic. It's related to my graduate article. So I'd like to know your opinion about the possibility of a state to be held responsible for like transboundary damage, environmental damage, perpetrated by a particular one, like a company, for example.
So if I well understand you, and this would be another course, international responsibility in the field of environmental protection, but what is at stake? And I think you have the pulp mills case, which was brought before the International Court of Justice, is an interesting one because it was Argentina and Uruguay. And there, Argentina was telling Uruguay, you have authorized companies which are going to allegedly damage the environment. And why I'm stressing this is that for the time being, we, international lawyers, we look at international responsibility at the international level through an interstate perspective. Okay, so the state, which there is a company, the company is located on the territory of a certain state, and an international law is telling these states, all the states, you have due diligence obligations to make sure that this company is going to behave in a manner which is environmental friendly and so on. Now, so that's the perspective of in public international law. What I think is interesting is that you start to have these transnational disputes, okay, where maybe before domestic court in a country, you can target a company which is located on the territory of another state for not having done what it should be doing, and so on. But we're starting with this, and we have it in the field of maritime catastrophes and so on. We still need to think about what more should be done, okay? And I think this is an important challenge. Thank you.
Thank you, Professor.
Thank you very much.
Thank you, Mariana. Professor Boisson Chazournes, we have no questions anymore, and I would like to back the floor for you if you have some final remarks about your speech and some hot points.
Yeah, where is my colleague? I don't see her. The nice colleague who introduced me.
Professor Tarin.
Yeah, maybe I would love to understand it, to have a reaction to what I said, and maybe Raphael, I will
Yes.
ask you afterwards.
Yes. In fact, I would like to question. I will do in French because I will speak in French for you. It's better.
Yeah.
En fait, j'ai écrit un article récemment, madame, sur les questions environnementales. Quels sont en fait les impacts des questions environnementales par rapport à les accords de commerce entre, par exemple, le Mercosur et l'Union européenne. Nous sommes en train de développer des recherches sur ces sujets et je pense que c'est justement une question très importante par rapport à votre exposé qui était vraiment brillant. Je vous remercie infiniment par votre exposé. Donc, je voudrais vous écouter. Qu'est-ce que vous en pensez, surtout sur cette question, sur la ratification du accord d'association entre le Mercosur et l'Union européenne? Quels sont les impacts actuels sur les questions environnementales? Vous pourrez même nous expliquer d'une manière plus générale quel est votre sentiment, votre avis sur cette question? Quel impact que les questions environnementales ont actuellement dans le développement des accords de commerce? Je pense que c'est une question très actuelle, très importante et qui a un impact très important dans le scénario politique du Brésil? Vous pouvez bien sûr répondre en anglais.
My colleague asked a question in relation to the sort of the relationships between the protection of the environment and free trade agreements dealing with the environment. So we're not speaking of the WTO, the World Trade Organization, but we're speaking of these instruments which are blossoming, where states are, negotiating trade deals with each other. And there is a big question, which is that there's been a negotiation for a long time between the European Union and the Mercosur countries, okay? And I'm not a specialist of this question, so I'm not going to give you a precise answer because really it's, I'm going to give you the perspective, what I've heard in Europe, okay? And then you can react. But what is interesting is that the citizens in Europe don't really understand the way free trade agreements are negotiated, okay? But what they want in these treaties that everything is said about the environment, okay? So they want to be sure that the meat that they will consume, because from Mercosur, it's going to be a lot of meat which is going to come to Europe because of and they want to be sure that the animals in questions are going to be fed in a question that is conform to the environmental protection. They want to be sure that there will now be deforestation because of the growing of pastries and so on. So what I want to say was that I don't know if it's right or wrong and so on, but what I think personally is that the citizens in Europe are no more trusting really their political representatives. They are not trusting them sufficiently to be sure that the agreements that they're going to be negotiating will be the ones that they would like for protecting the environment. Okay, so the people in charge of the negotiations of these treaties are all saying, but we've taken into account the environment and so on and so on and so on. But there is an issue, and that's a new term in international law, which I think is interesting. It's the notion of trust. Trust among each other, also the trust of the citizens towards the people who are in charge of the governance. And for the time being, it's quite interesting that this treaty is not, for the time being, there is a blockage. Huh? And so hopefully, what I think, but once more, I've not been involved in the negotiation, I've not worked on it, but what I think is that there might be room for common declaration of all the countries for ensuring that certain principles are going to be fulfilled. And maybe that would be a solution. But what I say with the WTO is also true, is that for the time being, for a long time, environment was, as we call, an exception. And in fact, we are all asking that the environment becomes more than an exception. But how to make that happen, I think that's the big question. And I'm not so sure that we have the answers. So I've answered partially to your question. Thank you.
Yes, sure. I have a second question. Is it possible?
Ask Raphael. If
we have more 15 minutes, and we have one student question.
Okay, okay. No problem. No problem.
But
please
you
Raphael.
have the floor.
No, Raphael, please.
No, we have time.
No, but we have more time. We have 15 minutes and more than la licence professionnelle, nous avons.
Bon, ma deuxième question, madame, c'est justement sur les pactes verts européens. En fait, ici, on essaye d'étudier beaucoup tous les documents que l'Union européenne est en train d'adopter, surtout dans le contexte post-pandémie. Et je viens de lire un document très intéressant sur l'économie bleue dans une perspective plus durable. En fait, l'Union européenne veut développer l'économie bleue pour assurer, en fait, pour l'implémentation des objectifs du pacte vert européen. Donc, je voudrais vous poser une question. Dans quelle mesure vous pensez, parce que je suis en train de faire des recherches par rapport à l'impact que le pacte vert européen va avoir dans les pays tiers. Donc, je voudrais savoir quelle est votre opinion par rapport à cet intérêt de l'Union européenne d'avoir un rôle très important dans cet changement de paradigme, parce que l'Union européenne veut d'ici 2050 avoir la neutralité carbonique. Donc, je voudrais savoir dans quelle mesure l'Union européenne sera capable d'avoir un impact dans les pays qui ne sont pas des États membres.
So the question is about the new initiatives which are conducted at the level of the European Union. And you know that in the post-COVID era, and I dare to speak of post-COVID, I really hope that we're going to get rid of this pandemic altogether. There is this idea that there is a major plan of action for transforming the economy in Europe. Okay, and one component of this major plan of action is the fact that the use of energy, it's related to the use of energy. Okay, and the European economy has been very much linked, dependent on fossil fuel energy. Okay, so the idea is that this should change, and we should switch. Because I'm European, we should switch to renewable energy. Okay, so a lot of money is going to be placed on, and also it's not just not using any more fossil fuel energy, but using better the environment and making sure that there is no leakage and so on and so on and so on. But there is, together with that, there is this idea that if we make all these efforts, should we import the goods and services from countries which are not making these efforts? Are we going to be subsidizing all these, new actions and energy initiatives, and at the same time accepting, the importation of goods and services which are not in conformity with what we want? I think it's a big question. It's a big question, and I don't yet have an answer. I know that the European Union is now speaking of a tax border adjustment, meaning that and this is linked to, maybe you will discuss that with others, it's linked to the idea of the price of the carbon. If you don't give a price to the carbon, there will not be any, says the European Union, there will not be sufficient incentive to change your economy. So that means that they want to impose a tax border adjustment measure that will ask the ones exporting goods and services to pay. And that will be the differential between what they've not done and what the European Union has done. Now, is it compatible with WTO? I think it's going to be a big question. Now, for me, this can't be the only measure, because this is once more fragmentation, segmentation, and so on. And Europe is very dependent on exchanges, importations, exportations, and so on. So I think that there is a need to discuss that worldwide. Okay, and it's a paradox, but I think that for me, that I may be wrong, but I think the WTO is going to become the forum for discussing these issues. And as the appellate body of the WTO has said, you need a multilateral approach for resolving these issues. You can't do that through unilateral actions. You need a multilateral agreed discussion. It's going to take time. It's going to take time. We will see.
Thank you so much, Professor. Please, Rafael.
Thank you, Tarin. Thank you, Professor Boisson Chazournes. We have one question from our YouTube assistant. The question comes from Giovanna Chirico. She's asking, Professor, the Paris Agreement is considered a hybrid treaty, that has binding and no binding articles. So, first, I would like to know if the non-binding part of the treaty can be considered soft law, and also would like to know your opinion about the mechanisms created to make this no-binding part effective, such as the transparency mechanism, and if they make the parties comply with their nationally determined contribution, NDC. Is a perspicaz question,
yeah? Thank you for the question. So, and we can exchange by emails afterwards, through emails, because it's rather a technical question for those who don't know well about climate change. What is interesting with the Paris Agreement is that the Paris Agreement was adopted as a treaty together with the decision of the contracting parties. And this why? Why? It's because of the big actor, the United States. And because President Obama said, I can only sign an executive agreement. So you can't change, you can't increase the obligations. So the increasing of the obligations were put in a decision of the contracting parties. Now, what is interesting is that, in fact, when we speak of the Paris Agreement, very often we're going to refer to the decision of the contracting parties to give some meaning to what we've decided. And there, I think that the term hybrid is interesting. There is a fertile hybridation between soft law and hard law, and we can discuss that further. But I'd like to attract your attention to one thing. Financial assistance is an important commitment of the northern country. Okay? It's not in the treaty. It's in the decision of the contracting parties. But I'm sure that it's going to be made effective because a lot of southern countries have put it as a condition for ensuring and promoting the protection of the climate. So I think that what I always say is that the binary approach, hard law, soft law, we should review it and look at it from other perspectives. Thank you, Raphael.
Thank you, Professor. So we don't have any more questions. Okay. I should to conclude right now because we are on our time. À la Suisse, ponctuellement. We are on.
Thank you, Raphael. It's a pleasure to see you.
It's my pleasure too, Professor. Yes. And, our first time as I became doctor to work with you now, and very happy about.
Yeah, I was going to say that Dr. Prado has written a very interesting book on the use of environmental principles. It was a pleasure to meet Professor Tarin, and I hope that we will be in contact. It's always a pleasure to participate to these courses. And as I've said, for me, as you might have seen, I'm a lively person and I like to meet with people in person. But we have to do with what we have. So I'd like to thank the organizers for organizing this and inviting me. Thank you.
Thank you, Professor. We have more, just 4 or 5 minutes for these final remarks. In the name of the organization and directed by Professor Leonardo Neme Caldeira Brandt, and in the name of my colleague Tarin, who I shared the organization of the management of this panel, I really thank you for your time and for your didactical panel and your lesson here. And we saw the reactions on Facebook and on YouTube, on streaming, and the reactions are much more fan positive. And this, I think that for a professor is one of the most beautiful thing to receive this feedback from students and scholars, right? And this is a kind of Global South, The Hague course we have here in Brazil, organized by Professor Neme. And it's good to congregate these professors from abroad and to have this brilliant assistants. Professor, I wish you a good continuation in Geneva and your endeavors. Thank you very much.
Thank you very much to all of you. Bye-bye.
Bye-bye. Thank you.
Thank you. It was an honor.